welcome to Par for the Course, Legal Issues Arising from the Game of Golf. I'm Lori Cripp Martin, a certified family law specialist and a past vice chair of the litigation committee for the Beverly Hills Bar Association. I'm delighted to introduce our speakers today, the Honorable Judith Ashman-Gerst and the Honorable Clifford Klein. Judge Clifford L. Klein is a mediator, arbitrator, and judicial referee at Signature Resolution. Judge Klein served as a Superior Court judge in Los Angeles County from 2001 to 2021, presiding over probate cases involving estates, trusts, guardianships, and conservatorships, including cases involving numerous public figures and entertainers. Judge Klein also presided over the nation's first full juvenile mental health court. Prior to the bench, he spent 25 years as a prosecutor in the Los Angeles County District Attorney's Office, specializing in complex business fraud cases. Judge Judith Ashman-Gerst is a mediator, arbitrator, and appellate consultant at Signature Resolution with over 44 years of judicial expertise. Justice Ashman-Gerst served as an associate justice of the California Court of Appeal, 2nd District, from 2001 to 2024. Her notable cases include an entertainment royalty dispute involving the estate of Michael Jackson and producer Quincy Jones, and a breach of contract case that secured a $500 million verdict for the City of Hope. She previously served on the Los Angeles County Superior Court and Municipal Court and held positions as Executive Assistant U.S. Attorney, Deputy City Attorney, and Deputy Attorney General. And now let's get started with today's program.
Thank you. I originally got into this unusually complicated field, I found out. I was looking up one question on a legal issue involving golf, and I was also doing more when I served on our country club board. A number of issues are not included because I have no idea how many there are. Perhaps the biggest potential case in golf right now is the antitrust case involving the LIL and the PGA. I did not include that for, among other reasons. I assume that's going to be resolved with a lot of backroom negotiating over financial issues. There are also, believe it or not, environmental issues that are Prop 65 warnings about chemicals on golf clubs. Of course, there are issues about how courses are treated with certain substances, and there are cases that are really not unique to golf, even though they may occur on a golf course or in a country club. Someone's driving drunk on a golf cart, fights, sexual harassment issues. The golf setting is not unique to those cases. All right, so we're not going to get into those. We have enough to do, and it may be a little superficial at times with all the topics. Next slide, please. Question I'm often asked is, what happens if I hit someone with my golf shot? Or by the better golfers, what happens if I get hit? Probably assuming I would be the one to hit them with a wild shot. We've all seen spectators get struck by the pros, as with many legal questions. The answer is, it depends on the facts. And the answer to this question can begin at our local Rancho Park golf course. Next slide, please. Next slide. Okay, yeah, and so we're going to talk about the doctrine of assumption of risk. Who is responsible if you're hit by a golf ball? Was the injury caused by a factor beyond ordinary play? And if I briefly use an analogy, you know when you go to a baseball game, you can get hit by a foul ball. You obviously know the risks of your skiing or horseback riding. So those are examples where you assume the risk. I was surprised to hear when a pitcher throws, I'm getting off topic to another sport, when a pitcher's throwing a beanball, that actually comes within the doctrine of assumption of risk. They're not negligent. Good news for all of us old Dodger fans, because Don Drysdale was known to occasionally throw beanballs. All right, next slide, please. The leading case. Skip. Yeah, next one after this one, please. Next slide. All right, the leading case is the Shin case that occurred in Rancho Park. The facts are fairly simple for any of us golfers, and that is there was a threesome playing at Rancho Park, a plaintiff and a defendant. Defendant's on the tee. The plaintiff goes up about 30 feet in front at a 45-degree angle. It almost sounds like an opening scene in Gunsmoke. The defendant looks to his left, checks his phone, drinks some water. The defendant, that is the person hitting the drive, pulls out his drive. He pulls the driver, hits the plaintiff in the temple. And the question is, did the defendant know where the plaintiff was standing, and did he actually stare at him? That's a factual question that was sent back to the court. And when I looked, I did not see results, so presumably it's settled. So the question is, was this a deliberate shot, not assumption of risk? That went back to the trial court. What the California Supreme Court held is there is a general duty of care on a golf course that is owed by a basic golfer. And that's basically hitting the ball. That doesn't mean you can throw the club. You throw the club at someone, that's reckless conduct that would not be covered by assumption of risk. It is your duty not to increase the risk, not to engage in reckless conduct outside the range of a normal game of golf. But it is no duty to avoid what is simple negligence that really doesn't apply in this case. Next slide. Next slide. So the question is, who is liable for the injury? And I threw in, does the defendant, the person who hit the golf ball, get relief? Our expert at our club, who is a rules official, says yes, the defendant gets relief in case you're worried, if he gets the hit over. Again, all right, next slide, please. So the Supreme Court, California, said the assumption of risk doctrine applies. They leave open the question, as I mentioned before, was his conduct reckless, meaning did he intentionally hit the guy when he was looking right at him? And there was a factual dispute. Next slide, please. So you have various factors you look at if you get into contributory comparative negligence. If you have primary assumption of risk where the defendant, that is the golfer, did not owe any extra duty to protect the plaintiff from any particular risk, it's a complete defense. However, if that's not the case, and there was some actions by the golfer above and beyond just the normal play, then you get into contributory or comparative negligence. Where was the person standing who got hit? In an earlier case, they made a distinction whether in the same threesome, foursome, or not this court. Were they paying attention? You look at those facts. In a case that I don't have cited up here, it's unusual for California. The victim didn't know in the late afternoon where he was out in the yard that their golfers were playing, and they, could hit into his yard from the third hole. And that's an older case which took a different view. But in any event, if the golfer who hits someone goes beyond the typical game of golf, typical swing, then you look at contributory comparative negligence. So next slide, please. So we have, again, primary assumption of risk, no duty by the defendant to protect the plaintiff from a particular risk. It is a complete defense. Anything can happen on a golf course. Secondary assumption of risk, the defendant still owes a duty of care, but the plaintiff knowingly engages in risky behavior. That's a breach of his duty. So he does have some responsibility. In other words, it's conduct beyond just trying to hit the ball straight. So basically, it's a limited amount of duty. Secondary, for example, it could be considered negligence if the defendant hits where he can't see. That could be considered reckless conduct. So I have a hypothetical, which I'm curious about Justice Ashton's response. And I haven't found a case of that. I just ran an AI. When I say I ran an AI, I'm obviously not preparing a brief, so I don't have the responsibilities to start reading all the cases. But I was playing one day, and it was very, very foggy, and I was up on the tee box hitting down onto the tee, onto the green. You couldn't see any. So the guys in my foursome, we sort of, go down there, and one yells to the other one, it looks like it's clear, etc., to avoid hitting onto the green when someone was standing there, because I think that would be considered reckless behavior. Now let's add a fact. We have a strict fast play policy. So one of the marshals comes up and says, you guys are playing too slowly, said to several of us. We've said, we can't see where we're hitting. And so when you throw in that factor, you could argue that the club also was engaged in negligent behavior because notwithstanding you couldn't see someone because of the fog, They didn't close the course. They didn't change the time limitations. In fact, they were encouraging us to hit quicker without trying to observe some safety factors. What do you think?
I think that the problem is, of course, the golfer is going to head for the deep pockets, and who's that? That, of course, is the course. But it seems to me that it's in my mind, it's really one of the risks of playing golf. The weather changes. Fog comes in, it gets to be heavy rain. You've got to leave. I think that all comes within the assumption of the risk, because you don't want to interfere with the purpose of the game and what's going on with the game. I don't know if you disagree with that.
I thought the club was negligent for asking us to play more quickly, and we get these nasty letters. Now, one of the fears you have whenever you do these classes is there's something that happened the last 2 or 3 days and you don't know about, and someone's going to ask a question. So there was a case, a verdict in Long Beach, $1.4 million, I think, within the last 2 or 3 days. And in that case, a lawnmower propelled a golf ball at 200 miles an hour and shattered a window where the plaintiff was in a clubhouse or somewhere ordering lunch. There, the trial court apparently found that it was not assumption of risk, that liability was based on negligent maintenance of a lawnmower. There was certain safety equipment they could put on to prevent balls and other things on a golf course from flying out, and they didn't do that. So they did not find it was primary assumption of risks. So if you saw that case, that's another application, and I wouldn't be surprised we have a Court of Appeal decision on that. Next slide, please. So as written in this case, I love this quote: if every ball behaved as a golfer wished, there would be little sport in the sport of golf. That shots go hooray is a risk that all golfers, even the professionals, assume when they play. There are a few other states who, vary. Some find intentional reckless conduct. Some find it has to be reckless, like in California, but I think that's generally probably the same rule in other jurisdictions. All right, next slide, please. So we're going to go into a new topic now, and that is when you go see the lawyer because you got hit by a golf ball. Next question by the lawyer is going to be, well, what about the design of the course? In other words, deep pockets. Was it a bad golfer or a bad architect? And let me tell you one interesting point. It's not on the slide. If you go on, one of these AI websites and I put in my course, not only do they list what they feel are faulty designs, but they actually have next slide, not our next slide. Well, you could go to our next slide, yes. They say, do you want to go to the next question, which is, shall we fill out the civil complaint for you against your golf course? Interesting. All right, negligent design. I'm going to turn that over to Justice Ashman, and it's very appropriate that she speak on this topic because one of the major cases in this area of negligent design was authored by Justice Ashman.
That was the Garcia case.
Next slide, please.
We'll get to that, but the concept of assumption of the risk also applies to asserting that the course itself caused the injury. One example of that is that Wellsfree case versus Ocean Colony. That one, there was a depressed drainage grate and someone fell on a wooden step and was injured. The courts are pretty liberal on what is assumption of the risk, because the whole concept, as I mentioned before, is not to destroy the nature of the game. So a lot of examples, even though that seems to me it could possibly be considered negligence on the part of the course, is not treated that way. So where does specifically negligent design come in? Well, it comes up when the golfer or spectator or someone on the course is injured. So the injured person, as we both have said, looks for the deep pockets. That's going to be the golf course, not your playing member. But under secondary assumption of the risk, the course might be liable And that's what we're going to talk about now. So in essence, the rule is that the owner of a sports facility has a duty to use due care to remove risks that are not inherent in the sport. Morgan versus Fuji case that really explains that further says the duty of the golf course towards golfers provide a reasonably safe golf course. Specifically, the design must minimize the risk that a player will be hit by the golf balls. So, for example, the way the various tees are placed, how the fairways and the greens are aligned or separated. Certain areas of a golf course, the golf course owner may also have a duty to provide special protections for players from being hit with golf balls.
And the reason we have this picture up there is not for the Rose Bowl, but that's the scene of the Garcia case. That's Brookside.
Right. Yeah. The Rose Bowl was really an interesting case, but that's going to get to in just a moment. So the example of if the injury is designed by the course, but may not cause the course to incur liability. But there are always exceptions to that. For example, what about the duty to a spectator at a tournament? We all know, we've watched on TV, somebody gets hit. And is that assumption of the risk? It depends, and that depends on the facts of it. What about depends on where the spectator decided to sit. Was there adequate protection provided for a spectator? Where were the stands placed? In those cases, there are tribal issues, so motions for summary judgment would probably be denied, depending on the facts of the case. So now we get to the concept of the duty of care. You can stay on that slide. Duty of care to non-golfers outside the course. So there's not really a good line of cases applicable to the liability of a golf course to non-golfers outside the course. But the law pertaining to landowners' duty not to cause harm to people outside the land would also apply. So, for example, there's a case, not a golf case, but it involves Sprecher versus Adamson, which involved a landslide on defendant's property that damaged a neighbor's house. Court explains that the duty analysis with respect to a landowner's duty goes back to our very, very favorite first year tort class, Rowland versus Christian. So this means there are lots of considerations, major of which are foreseeability of harm to the plaintiff, degree of certainty that the plaintiff suffered injury, the closeness of the connection between the defendant's conduct and the injury. So we would then also look back to the moral blame attached to the defendant's conduct and the policy of preventing future harm. So golf courses liability may be mitigated, of course, if a non-golfer outside the course acted unreasonably. For instance, ignoring obvious warning signs about walking in the area, and you might be struck by a golf ball. If you ignore that, then the course is null events is not going to be liable. So when else would a property qualify for immunity? So the Garcia versus American golf case, which, yes, in fact, I wrote, a boy was hit by a golf ball while he was on a pathway between the road and Brookside Golf Course in Pasadena. He sued the city as well as the operator of the golf course. And trial court found that the pathway was a trail and granted summary judgment for the city based on the concept of trail immunity. Now, what is trail immunity? Let's see if we talking about Garcia. We can go past to next slide.
Yeah.
Garcia. And my problem with this case, even when I was involved in writing it, was what's trail immunity? I had never heard of the concept before. So trail immunity, a trail is it's a pathway that's any trail that is used for access to hiking and recreational activities or scenic areas, which is not a city street. So whether the property qualifies for immunity depends on several of these considerations, including the accepted definition of the word trail. So the purpose of the trail is designed and used to connect recreational areas from one to another. So the Garcia case is often called the major case on trail immunity. So as I understand, in Garcia, the city moves for summary judgment on multiple grounds, including the absence of a dangerous condition on the trail, lack of notice of dangerous condition on the trail, and the applicability of trail immunity, which is within the government code. And I think it's section, it's not on here. It's section, in case you're interested, is government code section 830. So the city argued assumption of the risk. The trial court granted summary judgment for the city based on the trail immunity statute. The trial court, though, found a triable issue as to whether there was a dangerous condition, whether the city had actual notice of the dangerous condition, and whether the city took sufficient action to protect against the risk of injury. That's on the slide in front of you. And next slide, let's see.
The next side's a different case.
Well, okay, then I'm not finished yet. So let's say in Garcia, we reversed the summary judgment, deciding that the city was not entitled to trail immunity. We found no trail immunity because Garcia actually assisted the development of the law on trail immunity by discussing the policy considerations at play. So there are several cases that have focused on trail immunity and when it applies. One of the main ones is Amberger Warren versus City of Piedmont, which involved a woman on a trail with walking her dog and slips and falls, and that was found to be trail immunity.
I think we're a little behind. We should focus on the golf course.
Well, of the three cases, only Leyva involved a golf course. In that matter, Miguel Leyva was walking on a public path adjacent to Bonita Golf Course when he was struck in the eye by a golf ball. Court applied Government Code Section 834.1, the trail immunity, and extended this prosecution to private owners who provide property for public uses. So the trail provides immunity because it provides access to recreation. If there was no immunity, it would really discourage private property owners from providing and opening up those kinds of trails.
Here's a question, though, I mean, about this case is you found against the golf course because it was privately owned. Am I correct? And that they had the responsibilities for ensuring safety.
Yeah, we found that the trail immunity did not protect them. Yeah.
Right.
Mm-hmm.
Yeah. Should we go on to the next one? All right, next one. That's where the plane has land next to the golf course. And you want to handle this one, or should I? Sierra Products. I can. Well, I can briefly talk about it if you want.
Okay.
Plaintiff bought land next to a golf course, and they figured the use was permitted to have a golf course because they got permission from the city zoning laws. And the court found that there were two holes that really should have been redesigned. There was a continuing problem of the risk of golf shots going onto this property, and they did not find that the permitted use under the city zoning law was a defense. In that case, I believe it was under nuisance, they ordered the golf course to redesign both holes, just those two. So they can do that. All right, next slide. I think this is yours. This involves just a survey as an example of a number of examples where people sued on various things that come up with a golf course.
Right. Yeah. You can go through it pretty much yourselves. You know, the tripping on tree roots was foreseeable. There's no liability. The city path we have talked about in Garcia. One of them was it's a little bit different where trees were removed, separating fairways. When I mean removed, they were taken out completely, and someone was hit after that, and that was held to be tribal on the duty of care by the golf course. Ones that don't, you know, don't cause liability. There's wooden yardage markers. Okay, so the ball ricochets and hits the plaintiff. There's no liability because that's one of the possible injuries that you might occur. So you assume the risk when you play golf for that kind of issue. Also, there's a case that the Strand versus Connor. There are adjacent fairways, but there's no one that tells you really should be yelling for to make sure that somebody knows that you're ready to hit your ball. And they said, no liability. That's one of the risks when you play golf.
You know, it's interesting because there's another case which says that etiquette is irrelevant, and that is golf etiquette. The sanction is social disapproval. Of course, etiquette says you do yell for, but you can't use that as a basis of a lawsuit. All right. Can we go to the next one? Yes. All right. Here's an entirely different topic. Virtually every club member, I will guess, would answer yes to the question, are country clubs private? Is this the correct question? Obviously, I'm implying no. Hotel lobbies are private, but they can't discriminate. Restaurants are private, but they can't discriminate. And the workforce is changing, and I think that's an important policy issue. How many of your business contacts, for those of you in clubs, are club members? And if you're excluding certain groups, because we know historically they were only white males, there is a real detriment. I looked at my own situation and how many of my business contacts are in my country club. Eye doctor, electrician, roofer, physical therapist. You all know we need those when we play golf. Car dealer, air conditioning repairman, financial advisor, gate and fence guy, and don't need him yet, but my criminal defense attorney. So that's why it becomes an important question. And if we could go to next slide. Is the club private? Is it a business establishment? Or is it a public accommodation? And one of my surprises, many of us, or some of us who are older, remember the historic 1964 Civil Rights Act, which is the basis for public accommodations. They have that famous lunch counter from the South if you go to the Smithsonian. But actually, it specifically excluded athletic clubs. Have the language there. Can we go to the next slide, please? Next slide. Yeah. This doesn't apply to a private club or an establishment not, in fact, open to the public unless they're part of a establishment within the scope of subsection B. Well, subsection B is actually now being used quite a bit because that refers to public accommodations. All right. But that's not the most important law in California. I'll turn it over to the next slide. Justice Ashman.
Yes, the California Unruh Civil Rights Act is actually the premier law dealing with discrimination and requires that all persons are entitled to full and equal accommodations, advantages, facilities, privileges, or services in a business establishment. That means various categories such as sex discrimination comes up a lot in ADA issues as well. One of the important ones is Lerner versus American Golf, where a club member with a disability asked for accommodation. Case involved not only Unruh, but the federal ADA. So the member, for example, wanted to bring a golf cart closer to where the ball lands because of his disability. And he also wanted to get a special golf cart, so a single person golf cart. The club was really reluctant to do it. And actually the case wound up going to court before it was finally resolved. And the gentleman was given what they call a blue flag, we call it a red flag, and was able to go in areas where the other players weren't. The other players were getting upset with him at times and would make comments. So one of the things he did was have the club assure them that he was following the rules as required by the club. As it turns out, probably this guy had some issues with some of the other club members because they were making this, a personal thing. And he also at one point threatened to get in a fight with the other golfers. So run under overlaps with private club issue, as mentioned by Cliff. So is the club truly private or is it a business establishment?
I think we should go to the next slide on that.
Well, I had,
There it is.
well, you're going to talk about Peninsula.
I am?
I think. I thought
all
I
right.
you were going to discuss it.
I'll talk. I can talk about it.
Well, I just want to
Yeah,
mention
I'm sorry.
a couple of
Yeah.
things quickly. When I passed the bar in the early days of the common law, there were several private clubs in downtown LA that were out of bounds to women lawyers. In one, women were simply not allowed. Another, you could go to a meeting, but you had to travel the back elevator that the help used. So that was really prevalent in the early days, and also employment. So we get back to private clubs, whether it's a business establishment or not. The most well-known is Warfield versus Peninsula Country Club. In a country club setting, potential violations of under civil acts generally arise when the club denies full and equal access, services, or privileges. Private golf clubs, country clubs, often sit right on that line between private clubs that's exempt and a business establishment that's covered. So liability frequently turns on how the exclusive club really is in practice. So there are a lot of ways of determining whether a club is private or not. Denying membership based on race, religion, and national origin. You can get in only through an old boys network by having a local sponsor. Unequal access to facilities or privileges. And it goes on. Having a men's grill. There used to be a men's grill in a lot of the clubs. I think there probably still are. And having restricted times for use of the golf course by women. Times, days of the week were fairly common when I started playing golf. But getting down to the threshold question, and I know that Cliff will have something more to say about this. The threshold question is, why is it important to be a private club versus being a business establishment? And it all goes back to money. Because if your private club starts bringing in outside income, you're hosting political discussion. You're having bar mitzvahs and weddings at the club, but you the member are not in fact paying. Using the club goes out into the public for these events. So the clubs have become much more concerned about them, although I think some are a little bit looser than they used to be. But the big thing is, if they are deemed to be a business establishment because of the way they're conducting this outside business, they may lose their liquor license. And that's a big thing. So as we look at other clubs, we see that there's a club in Palm Springs, in the Palm Springs area, I don't know exactly where no women may be members, no women can be guests, women can't come on the property, can't step foot on the property, other than on Christmas Day. And I know there was a time my husband was playing in some group and it was going to be at that club. I couldn't even drop him off at the club. I wasn't allowed to drive. That didn't last very long for us. It was,
You laid down the law.
yeah. Okay.
I'll talk about Peninsula. I don't know, but all right. So Peninsula is the big California Supreme Court case on this issue where they found that Peninsula didn't let in women, and they found with a business establishment, it was not a private club. And they set up a bunch of criteria, and I'm going to prepare Justice Ashton because I'm asking this question about how much precedent this case will really receive now. So they look at factors. Did they regularly receive income from fees? I want to go to the next slide, please. Next slide. Yeah, did they regularly receive income from fees for the use of the facility, sponsor events? Did they get a financial benefit from non-members' use of the pro shop, which was open to the public? They let the high school team use it. Guests could pay cash for food or drinks. Next slide, please. Is that the next slide? Yeah, they looked at the factors in most cases as it's selective versus allowing, the public in, which I always found interesting because if you let everybody in, you would think you'd be more diverse. Size of the club, if there's 700 members, it's less of it's more of a commercial establishment. How much do the members actually control? How much do non-members use the club? Is the primary purpose for business or social? Now, and they found that Peninsula flunked this test. But my question for Justice Ashman, our appellate specialist, is they didn't cite any specific numbers. How much of the income was received from use of the facility?
Right.
These kinds of issues. And I think we both agree, being members of the club, they're bogus anyway, because I'm in a national network where people call, I'm in town, can I play? They pay the guest fees. People are regular guests pay guest fees. You host an event and people chip in if it's a baby shower. So the stats are misleading if they present them. So my question about the precedent value of this case, they didn't list any specific numbers. And the other one is, should it come up again, this California Supreme Court is very different from the one decided the Peninsula case. There are currently 6 members. Everyone is a member of a class that was historically excluded from country clubs. There's a Jewish member, Justice Groden. He's Jewish. Jews didn't get into clubs. The others are all people of color. Do you think this case would stand were to come up again in front of the California Supreme Court?
Yes. I think really going through the facts specifically as you did.
No, I meant, would they change the criteria since they didn't give any specifics?
No. I think it's very vague. The selectivity of admissions, how do you deal with that? The size of the club, 700 to okay, but is 1,000, too many. Degree of membership control, who's really controlling the club. And as you mentioned, the use by non-members.
So my question is suggesting that a lot of these clubs, if they get in front of the California Supreme Court, will be in trouble.
They'll be in trouble.
Yeah, it's going to be less than pathetic.
Yeah.
All right, next slide, other state laws. I'm going to summarize this very specifically because it shows some difference. Maryland, you don't get a property tax deduction. Remember that one. Connecticut's prohibited by statute. Michigan, prohibited by statute. There's no weasel words like you have in the Civil Rights Act. Florida, there you get into more looking at factors. Statutory, no, you cannot discriminate. New York is more like California. All right, next slide. I find this one very interesting because one club litigated this. All you golfers know Pine Valley, one of the most renowned clubs. But in New Jersey, they have an anti-discrimination law. The other difference in Pine Valley is it also included a lot of the members own real estates, and then you get into housing issues, which we all know you can't discriminate on who you sell your house to. So I thought the settlement was very interesting. I bet the Pine Valley members are sorry they ever got into this. All right, no discrimination. They probably knew that was happening. No restricting lease of land based on gender or club membership status, so you can't not say that blacks or women or Asians can't buy houses, which historically was obviously the situation, California, other places. But now we get into must provide all persons, including women, transgender, whatever, equal opportunities to obtain employment. Okay, next slide. This is the one where I bet some of the members were going, oh my goodness. Cannot bar any employee from wearing earrings at work on the basis of gender, gender identity, or gender expression. Any of you club members, you know how most club members feel about they're very conservative on dress. Cannot prohibit any employee from appearing, grooming, dressing consistent with their gender, gender identity, or gender expression. I can imagine in my club what they would think of that. No editorial comment on my point, but you know, some of them would, it's coat and tie. And they have to go to anti-discrimination training, which, of course, we all have to as members of the bar. Next question. All right, a couple other sanctions. Some clubs say we are not giving in. And there's a well-known club in Illinois. They can discriminate, but they lost the PGA Western Open. There's a club in Maryland. I'll name Burning Tree. They've had 4 presidents, Supreme Court justices, congressional representatives. I love this story. Edward Murrow reportedly learned of Pearl Harbor on the 10th tee, but he finished his round. And they do not have a tax exemption, and it goes up every year, and it's up to $1 million. But they have, my understanding, is a policy as the one that Justice Turlin mentioned in Palm Desert. Next slide, please. There are other sanctions. Some occupations, like judges, the Judicial Code of Ethics says you cannot be in a club that discriminates, but they use the word invidious, meaning arbitrary. So if you're in a club that, let's say a Jewish organization, that's not going to be considered an illegal club under or a violation of the Code of Ethics. Signature itself has a disclosure form similar to that. Liquor license is actually an interesting one because I researched that in the California law, virtually every type of club, they must list 20 kinds of clubs. They say you lose your liquor license if you discriminate, not country clubs. For some reason, there was a bill to include them, and that went nowhere, I believe, in the early 80s or late 90s. They do say if you have a liquor license and you serve liquor and you discriminate, you get something on your invoice that says it's not deductible, but I think it's not deductible anyway. So there are other sanctions out there. And what makes it difficult to enforce the membership ones is there is a conflicting statute or policy which says there's rights under the First Amendment for freedom of association. So you may not have to disclose your list should it be challenged. All right, other jurisdictions, next slide. I'm going to skip that. That just shows that some of them who had racist policies were not allowed to continue the discrimination when they had lawsuits. There's some federal cases. Again, you have that little small thing about public accommodation. And if I may summarize the criteria, if they look at selectivity based on protected categories, that's most important. Obviously, as we talked about, certain historic groups that have not been allowed. Did they advertise or solicitate? If they do a lot of advertising, that's more of a public club. Internal governance of members, that's more of a private club. Use by non-members, that's a big one. That, of course, is a public club. All right, next slide.
Want to move on to?
Next slide, please. I will turn it over to you. I don't know if it's a perfect analogy. We have a designated hitter rule in baseball for our older players who can't field anymore. Should they be accommodated? Well, what about golfers who can barely walk? I'll turn it over to Justice Ashman. Disabilities. Next slide, please.
Big case there
Yes.
on disabilities, please, is the case of PGA Tour versus Martin. So closely related to the other discrimination issues, the disability issues has come up very recently. And the Supreme Court was asked to decide whether professional golfers who could walk with difficulty should be accommodated. The decision came down in 2001 in the case of PGA Tour versus Martin, and he sought the ability to drive in a golf court. The Supreme Court found that riding was not an advantage over walking and permitted Martin to drive. So the decision was based on the PGA being considered a commercial enterprise and that its tournaments were places of public accommodation. under the ADA. And other cases have really dealt with disabilities and not discrimination. So I had previously mentioned the golfer at a private club who was initially just denied the an accommodation, but subsequently was provided the blue card and the use of a special golf cart. So any events that occur on a golf course identified by the Act as a public accommodation cannot discriminate against any individual in the full and equal enjoyment of the goods, services of the courses. And that includes going as far as the Q schools, which are for golfers trying to get on various tours.
Yeah, I think they may have allowed riding in youth school and of course, in the senior tour and even pro tours.
Yep.
Transportation from the 9th green to the 10th tee. But I love this quote. Can we go to walking versus riding? Go a couple slides. There. So according to the Supreme Court, it's the same energy level. Some of you, such as myself, may question that. I get tired when I walk instead of ride, but they found an expert to say otherwise, and it's our U.S. Supreme Court. All right, so they're right. Next slide. Very topical. All right. Skip that one. Skip that one. Duplicate. Skip that one. Transgender competition. All right. Just yesterday, the International Olympic Committee made a ruling on transgender competition. Next slide. All right. So a lot of agencies get involved in this. The California Coastal Commission ruled that a women's surfing competition had to permit transgender surfers. So what happens to Pebble Beach and Torrey Pines and the California Coastal Commission? The Coastal Commission has jurisdiction over equal access, not sports eligibility, but in ruling on equal access, they of course can make decisions about sports eligibility. So it's not, in their view, just fences and gates preventing beach access. Earlier, there was a controversy when they made a ruling on curfew on the Venice Beach, disagreeing with the city's efforts to enforce it. There was another controversy over Elon Musk shooting off rockets. And the LPGA, of course, is looking at competitive fairness and physiology. So the question is eligibility in a sporting event a permissible classification? Are they, you get into sports governance, or is that illegal discrimination? We have the Olympics coming up here. We have international treaties, contracts. Please, no one asked me what's going to happen with beach volleyball. Next slide. So this is the LPGA rule that after male puberty, they can't complete it anymore. We're going to learn a lot about this next year. That is the law. Next slide, please. Because there are two cases going in front of the United States Supreme Court, two different states, I think the other one might be Idaho and West Virginia, have passed statutes restricting participation in girls' and women's sports to athletes who are born female. The Court of Appeals, two different circuits, enjoin these laws. It's going up in front of the U.S. Supreme Court. Next slide, please. And the question will be, is discrimination substantially related to the stated goals of equal participation and opportunities for women athletes? And are the procedures to decide if they are trans athletes unnecessary and invasive requirements that they have to undergo? The invasive requirements were, I think, about 40, 50 years ago, much more invasive. So those are the two issues that will be coming up. Coincidentally, just to let you know how topical this is, there was a golfer, Haley Davidson, who I believe he's the one who actually got to the second round in Q School. She is now suing the USGA and the LPGA. I think it was filed this week against discrimination. So we will see where this goes, because it's really not the California Coastal Commission that's going to decide this issue. It's going to be the Unruh Civil Rights Act. That's going to be the one where it provides, it prohibits discrimination against people based on their sexual orientation and transgenders. And so you very likely will have a lawsuits like Haley Davidson's. I don't know if that's in California. That's probably a federal case dealing with the conflict over, well, you all know it's been getting a lot of publicity. When we get to the Olympics, you have international treaties and international contracts. So I think we know where I'd be surprised if state agencies had any relevant say on that. But when we get to some of the other situations, I suspect there'll be some litigation, and it's hard to tell how the courts will come down on these competing interests. Next slide, let's go to, this is a quick one. Those of you who are country club members.
Oh.
There are always disputes by members. And in my club, my president, past president who read this, came up to me and said, this is interesting because guys are always saying, I'm going to sue the club. We had a situation where there was a dispute over the calendaring in a match play tournament. And he threatened to sue. So the question is, where are these lawsuits going to go, Justice Ashman?
Well,
what court? Next slide.
The courts aren't really interested in us. The courts are really not eager to hear from clubs, to hear
next slide,
disputes
please.
by the members
Yeah, there
of
it is.
country clubs. But many courts have the board of directors or a rules committee to resolve disputes. In Cobb versus Ironwood, which is a California case, former and current members brought an action to seek declaratory judgments as to a club's obligation to repay land purchase assessments. This is something that's coming up more commonly for the clubs that are member owned. The club filed a motion to compel arbitration. Trial court denied the motion and the club appealed. But what had happened in that case is bylaws had been amended retroactively while the case was already in court. So the Court of Appeal affirmed the public policy facing arbitration did not favor retroactive application of the amendment. Another recent case, disgruntled members of a club did seek arbitration, and arbitration was in the bylaws. It went to arbitration. The members lost based on the interpretation of the bylaws. The members were thereafter expelled from the club on the theory that because these disgruntled members also sued the individual members of the board in their individual capacity, those members were invited to leave the club, which they did, because they their conduct was unbefitting of the club when the board members were sued in their individual capacity.
All right, if we can move on now to intellectual property, let's go to that slide. I'm going to go very briefly over that. It's a complicated area, and I'm going to basically skip most of the slides. If you could, next slide. Yes, yeah, carpenter, the tools. We all like to think, given the right club, maybe things will change. But anyway, I'll just say that the major case going on right now is tailor-made 790 irons used by some of the top pros versus Costco in Kirkland. And these are the various issues that come up: club heads, cleats, balls, practice mats. There was an issue over Kirkland golf balls, which actually turned out to be patented. There was a problem with how they were made. So that's the big case. There's a $900 difference in price. The Costco one sold, I think, in few hours when they first came out. Costco's famous, people love it for the wine, the batteries, the high price vodka, and the cheap, Costco prices, the $1.50 hot dog, etc. On the other hand, you've got TaylorMade, which has taken historic pride in being very innovative in the golf business. They were the first to, I think, go to metal clubs versus the old persimmon, and there are other areas also. Can we go to the next slide that shows a diagram of the two different slides? Just move through. Next. All right, next. Yeah, the next slide. Next slide. I just didn't go through all right, there we go. So back to that one. So there's a difference in the two, and you see in the red, it's the inserts. Next slide. All right, Taylor says there are hollow body design, strategic weight placement, speed foam technology, etc. Next slide. They say also that guess who went to work for the design company that Costco used? He used to work for TaylorMade on B-79 irons. They have the secret design team. Next slide. All right, Costco has various defense. Older irons are similar. Some of these are required by the rules. The foam is different. The technology already exists. These are critical issues in patent law. Next slide, please. And then there's an issue of equivalence. Does it perform the same function? In which case, there would be a patent violation. Next slide. All right, and you can see how many times we have patent disputes. These are all the companies, all very well known. AstroNet, I think, makes a lot of some of the products, maybe for Titleist, I'm not sure. You know, as a retired judge, I was thinking about this because you obviously have a lot of engineers who are going to be doing all this research. It's very expensive case to prepare. And right now it's on appeal. The issue is, I believe, Costco wants to go to arbitration. TaylorMade wants to have a jury trial. I will say this would be a tough case for a judge to try because you have all this costly research. And how do you prevent, you know, you go on the web and they got guys talking about, oh, I hit the 790, I hit the Kirkland, and whether it's the same or not. Or what do you do? I don't know. Well, you have jurors who go into the driving range trying it for themselves and saying, so much for the experts. So who knows how that'll turn out. We're going to...
Yeah, Cliff, just to clarify, I know nothing about golf clubs, except I always want the newest and the best because that's going to change my golf game.
Right. And boy, do those clubs, there are a lot of people like that, and they go on and on about it, and then you get the new club. All right. I don't know how much more time we have. I think I'm going to have to really go to the conclusion, except for I was going to talk about the PGA authority to limit and outlaw golf equipment. The big case there was Ping. Ping challenged it because they didn't like the U-shaped grooves. They had golf people testifying on both sides. You had conflict of interest things because all the pros on the committee had contracts with the companies, and it was very hard for the Pings to retool it. So they got a preliminary injunction saying it would be very difficult for Ping to change the contracts for the golfers, to change production facilities, and then it kind of went away. But one of the interesting things on cross-examination of one of the experts, one of the pros, is the golf balls. The pros, they're not using the same Titleist Pro V1s that all of us are using. Turns out they tweak them a little. So I found that one of the interesting facts. Property tax, Malcolm Gladwell, Justice Asher.
Well, that's pretty simple. It takes just a minute to tell you that nonprofit golf courses and clubs cannot be reassessed. Why is that? It's commonly known as the Bob Hope exception. So clubs are nonprofit and cannot be reassessed based on a change of ownership with every new owner.
Yeah, and you go to the next slide. That's what Bob Hope got enacted. Because I know there's always worry, with clubs like Bel Air, et cetera, Hillcrest, they're in pretty high-priced areas. What would happen if they had a property tax reassessment? And Malcolm Gladwell is always complaining about all the tax revenue that's lost simply to subsidize the wealthy. All right. I will conclude with an example of great legal scholarship. Next slide. Look at what a justice wrote. Fresh air, smell of pines and eucalyptus, recreation with friends, meeting other citizens. Oh, I wouldn't mind meeting Roy McIlroy. It can be a very social event. Neighbors benefit by scenic green belts. Golf brings wildlife enjoy, and not big in the coyotes. So the law should not discourage participation in such an activity whose benefits to the individual player and to the community at large are so great. What beautiful legal writing. So the final exam question for you to get your MCL credit is this. According to case law, when you leave your family to play golf, are you contributing to the public welfare? Yes or no? There's your case. Thank you. I think we finished our
Yeah.
hour just under the gun.
All
Do we
right.
have any questions or?
Do we have time for questions?
Yes, we do have time for questions. It looks like we have one question from Laurel Starks. Let's see. I think this is in reference to a earlier portion of your program. Would this suggest that the existence of a quote unquote men's card room that is located in a prime location of the building and men's courtesy tea times would fall within discriminatory practices if it is classified as a business establishment?
Well, I've wondered about that because my club is certainly very diverse on its membership. The men's card room is near the locker room, so we don't have that issue. Yeah, you have tea times, but there are bigger issues, is my thought right now, than that one. I think membership is really where, if we see anything, that's where the attacks will be.
Right. I think a lot of the clubs are getting rid of men's card rooms, women's card rooms, and they're just all card rooms. And the only place that there's any division there is up where we have a gym up there. And so there's, of course, obviously the men's area and the women's, but everyone can use the equipment. Everyone is invited to use the equipment. Everyone can use the private rooms for like Pilates or whatever. And there is a separate area for men in the men's club area, and there's another for women in their area, obviously. So there haven't been any complaints about it in recent years.
And I think, in the case of mine, the clubhouse is old, and so you have certain things like the men's card room is near the men's locker room. But I'd just be surprised if that's where the attacks would be on country clubs, considering what's out there, especially in other areas.
The tax is going to be on general membership issues, in my mind.
Yeah, because our women members, you don't usually see them there on Sunday morning, but we have women members and they can play on Sunday morning.
So it used to be that the women couldn't play on Saturdays because, of course, the men are working and the women are not working, so they can play during the week. But I think that old concept has gone with the wind as well. In our club, everybody can play on any day, except that women do get Tuesday mornings. And they have team and they have competitions and things. But at 11 o'clock, it's then open to everybody.
Yeah, I was in membership committee for 7 years, and I felt very, very comfortable. And we just allowed, an openly gay couple to join. So there is progress.
Yeah, there's nothing at most clubs that have anything to do with couples. They may have a requirement that the couple, the people, whether they're two men, two women, doesn't matter, are sharing the same residence, if they are in a relationship. That's the only little, complex that we have. For ours.
A lot of clubs are going that way, people living together.
Anybody can come in, yeah.
All right.
There's one issue about the transgender when you're talking about the former.
Well, I don't know. But a very good, athlete who's transgender. She does not play in a women's tournament.
Correct.
But that's by choice, I believe.
Yeah, I think that's just by agreement with the club. Yeah.
Yeah.
Right. Anything else come up?
Righty, well, it looks like that's it for questions. This concludes today's presentation. Thank you so much, Judge Klein and Judge Ashman-Gerst. And thank you so much to our audience. Have a great day, everybody.
Thank you.
See you on the links.
Bye.